Welcome back to the Law News Network. I'm your host, Caroline Polisi. We are on a lunch break in the Jessica Chambers trial. That is the trial in which Quinton Tellis stands trial for her murder. I'm joined in studio today with live analysis with Michael Bryant. Michael, thank you so much for being with us here today.
Hi, Caroline. Happy to be here.
Thanks. We kind of got into talking a little bit about the case off camera, and I said let's cut right away because we were getting into some really good stuff. We both feel pretty strongly about this case. We started off talking about how I, for one, heard openings in this case and felt pretty strongly that the state was going to really deliver us some pretty good, solid evidence here. What's happened since then?
Well, you know, when we talk about the opening statement, there was a lot going on here that should never have been allowed. The defense just kind of sat on their hands. When the prosecutor prefaces one of his statements by saying, now, I should save this for closing argument, but he gives his argument, and that argument includes a suggestion that he knows exactly what happened during what we now know is that missing hour.
Right,
you know,
the mystery hour.
Yes, that's when the suffocation took place. That's when the plot and the plan to burn the body took place. Well, you can't do that in an opening statement, and the defense did nothing. Now, what I tell juries during an opening statement is, hold me to what I tell you right now. When we circle back and I'm doing my closing argument, remember what I said, take notes. And if I don't hit those points and give you what I promised, I failed. You got to hold that against me. Don't hold it against my client. But I'm telling you right now, here's what's going to happen. Check me when we get to closing statements. I haven't seen yet what's been promised during the closing statement / argument by the prosecution.
Right, classic sort of over-promising and under-delivering, which is never a good tactic in opening statements. I myself was shocked about this DNA piece, the piece of evidence that the prosecution really hammered home. Apparently this was like a smoking gun piece of evidence that Quinton Tellis' DNA was on her keys, ladies and gentlemen. Boom, there you go, case closed. I mean, I'm so angry at the prosecutor for, again, over-promising here, because talk to us about this DNA evidence.
The smoking keys.
Right, exactly.
They were not there.
Exactly.
I mean, let's face it, if this guy, if Quinton Tellis had been a total mystery man, no contact with the victim at all, and just out of the blue he was connected through DNA to the crimes or the crime scene, now we got something. This is a guy that's been with Jessica in the biblical sense as well as many other, and he drove the subject car, probably touched the keys during one of their rides, if not when he actually drove the car. What's the big deal?
Right.
I mean, the fact that the DNA was not even conclusive, we couldn't rule him out. I mean, who cares?
Well, that's my issue with it. I mean, they're saying, again, you know, just from the start we knew it wouldn't be a big deal if his DNA was all over these keys, because they had a consensual relationship 2 weeks prior to this. So it's not out of the realm of possibility. They were driving, he admitted to them driving in the car earlier that day. It was sort of the characterization. I think if I were the defense, I would have objected to the characterization of, in this opening statement, leading the jurors to believe that, look, he didn't say it was only Quinton Tellis' DNA, but he didn't say specifically that it wasn't specifically his DNA. It was just that his couldn't be ruled out, excluded.
Yes.
Additionally, there were other unidentified male DNA on those keys. That to me is a case that cuts the other way for the prosecution. If I'm a prosecutor, I don't bring that up in opening statements because I look really bad. When it comes out, I look less credible to that jury when they find out that I kind of misled them a little bit in the opening statement. What do you think?
That's it? I mean, it was just a little limp.
Right.
You know, there just wasn't enough there for the jury to say, aha!
Right.
You want those aha moments, and this was not one.
Right. We heard, actually, speaking of aha moments, we were just hearing from the investigator in this case having some of those aha moments with Quinton Tellis when his story wasn't sort of adding up in the second interview after they had initially spoken with him. But we'll get to that later. I want to talk about what everybody is talking about in this case, the dying declaration of Jessica Chambers. Initial thoughts.
It's like 7 dying.
Yeah, exactly. 14.
It's not, and to be honest, I think the Derek is a red herring here, because I'm not so sure that wasn't just a construct of some one person mishearing Eric. 7 people, as I count, said Eric pretty clearly. You know, they heard it, they wrote it. You know, there was no question about that. I'm a little concerned that the defense didn't pound away at that and say, you know, is there any way that you didn't mishear that? That it was somehow Tellis or Quinton? I mean, is there any way you didn't? because they were all pretty solid on what they heard and what they recorded in their reports. So I think that is brutal. I mean, unless we start seeing more, this jury's going to be a little annoyed that the evidence seems to point towards something other than the prosecution promised.
Right.
You know, remember, here's what I think is really important as we get to the end of this trial. We're heading toward closing arguments, soon enough if they're going to work through the weekend. The prosecutor has the burden of proof. If the defense is not going to put on a case, and they're just going to say, well, Mr. Prosecutor, you didn't do a heck of a job, we're going to stand pat, I think that helps the prosecution. The reason is this: the jury wants to hear from the defense in other ways rather than just cross-exam. Sometimes the defense case is cross-examination, period. That's not all that unusual. But if I'm the defense in this case, I'm going to seize on this Eric issue, and I'm going to see who I can get back in, what additional witnesses I can find to reinforce that identification. Because
so
then
you
you've
would
got
recall prosecution witnesses, or you would call your own defense witnesses?
Well, here's what I think they've caused problems with. By this I mean the defense. They have excused all of these first responders who made this oral identification and record keeping. They would have to make some motion to reopen so that they could bring those people back. If they don't bring their own defense witnesses, I think they should have excused those witnesses subject to recall in the defense case. They didn't do that. So they'd have to bring some motion to have the judge to open that up again. Not a big deal, but
right.
Why bother?
Why not?
Those guys didn't want to hang out in the courtroom, which is the only reason to finally excuse them. If they want to hang out in the courtroom, then sure. If you want to excuse them and hold off until maybe later, then they're going to walk out the door just like they did. So there was no harm by trying to reserve their testimony or additional testimony in the defense case. They didn't do that, so now maybe they do bring some additional witnesses that they're aware of that others may not have used to reinforce the Eric issue. So now you've sandwiched the case. You've got the start of the prosecution case with all this Eric, Eric, Eric. You button it up with your defense, Eric, 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 and it's tough to overcome unless we see a whole bunch more.
Right. I tend to agree with you. I feel like juries, we all know in this field that the defense is not required to put on a case, obviously due to the nature of the burden. But juries want to hear a case from defendants. However, I feel like this case in particular, if there's any case I've seen here at LawNewz, this is one where I feel like the defense could just rest upon prosecution's closing. I mean, they could just say, and that I sort of got that feeling from the defense attorney in her opening statement, which was very short. Remember, in comparison to the prosecutor's opening statement, it was pretty pithy. So I think she did sort of allude to the fact that perhaps they would put on a case in terms of cell phone evidence, and I think that's something we want to talk about. But again, if there's any case I've seen that could qualify for one of these just sort of defense rests, this would be one of them. Sometimes I feel like if you put on sort of a puny defense case, it almost hurts you more than having just rested after prosecution's case, because when you do that, you present sort of an aura of confidence to this jury that, look, the prosecution's case was so pitiful that we're not even going to put on a single witness
risky.
here. Yeah, it's
right.
risky. It's risky, but it's a tactic.
Tough call to make.
It is.
And it'll be very interesting to see what they do. Are they going to do the hands in pocket defense and just
right.
say, didn't do it? We know there's going to be a motion for directed verdict.
Yes, always.
Preserve it for appeal. It'll
always.
be denied. And then, following that, it's either defense rests or we have some witnesses and let's go.
Right, and it felt like we were going to hear from some cell phone experts.
To me, that makes perfect sense.
Yeah,
I mean, we haven't seen the prosecutor's
right.
expert yet, but from what I understand, you've got the cell phone records collected, examined, reviewed by the cops. The numbers don't quite match up. The locations don't quite match up. I can fix that. Let me bring an expert in who can massage those ping points and come up with a better graph, a better map of who was where and when, which is, as I understand it, what the prosecution did. First of all, to me, that leads the analysis subject to attack, because why wasn't the custodian of records or the person providing the cell phone data, why wasn't that good enough? Why did you have to bring in an expert to put that stuff together? Because we're not smart enough to figure it out? I mean, why'd you do that? But once it's done, the defense really needs to bring somebody in and say, look, this stuff's not that scientifically accurate. We're getting better. The numbers are getting better, the way we can locate people when and where, but there's a huge margin for error here.
Right.
So I'm hoping that at the very least the defense brings that kind of rebuttal expert in.
Right. Unfortunately, it is a common misconception that we can track people directly based on this cell tower data when it's really much messier than that. The towers are split into 3 sectors, and then it's a question of where you ping on this sector. We saw this, I don't know if you followed our Holly Bobo coverage, but this was a huge deal in the Holly Bobo case, and those experts really, a lot of our viewers felt, sort of cancel each other out. We couldn't rely on either of those testimony to really place the defendant with the victim at the time. It just wasn't conclusive enough.
And if it does cancel them out, what does the prosecution have?
Exactly.
If they can't recreate that missing hour, I don't know what they've got.
Right. What do you think about the timeline? People, there's this whole the green dot, the fact that he went to retrieve this ATM card later that evening. Does it match up for you in your mind?
It's really a question of whether we believe Quentin Tellis was smart enough following a horrific crime to try and cover himself. Okay, because otherwise it's an innocent alibi. Otherwise, yeah, I was just up there. It just so happens it was at the same time as the crime, but it's not very devious. So it depends on whether you believe this guy is innocent in and of his own actions and was just coincidentally getting a card, or was he so devious, so clever that he said, whoa, I got to create an alibi, and here's how I'm going to do it. I think it cuts both ways, and it's unfortunate we're not going to hear, I don't think, the defendant's testimony on that subject. We're hearing the best we're going to hear right now through the interview. I mean, that's one thing the jury is going to be eating up. They see the guy sitting there for days. They don't get to hear from him on the stand necessarily, or likely, but here he is in this interview setting. They can hear his voice. They can hear his manner of speaking. They can see his body language. This is critical stuff for the defense as well as the prosecution.
Absolutely, and just to that point, on day 1, we saw Quentin Tellis get really emotional in that courtroom. He was crying, wiping tears from his eyes. I thought that was interesting. I did not expect that from this defendant. And I also thought it was really interesting that he accompanied the jurors on their site visit yesterday, uncuffed, unshackled, just kind of there as part of the crowd. It leads me to wonder whether or not that jury was sort of paying attention to his demeanor and looking for clues as to whether or not they believe this guy, whether or not they think he is capable of this horrific crime.
Yeah, I'm sure they were. I'm sure they're sizing the guy up both in the chair and out in the field. Of course, out in the field, the defense is not going to allow him to be shackled or in prison garb.
Right.
It might be a little prejudicial. So he's going to be allowed to kind of roam freely as best he can, and he has a right to be there. It's part of his trial process. But those jurors are now seeing him, in the wild, for lack of a better description, and they can see how he interacts with his handlers, because the bailiffs are around to make sure he's doing the right thing. It's all critical info that they're going to take in. As to his crying when the process began, if you were cynical, you could suggest, well, here's a guy, he's already in prison, staring now at another potential stint for life in prison. I got another case pending that this jury won't find out about in a neighboring state, another horrible murder. It could just be all too much. The guy's it's just sinking in, and he's not so much sympathetic as he is scared to death about his future.
Talk to me about this other evidence. We saw in this interview from Quentin Tellis, he was actually in custody at the time because he was serving time for another crime. Talk to us about this. This is like, you can't make this stuff up. Truth is stranger than fiction, but talk to us.
Yeah, I mean, again, this is the stuff the jury is not going to hear for obvious reasons, but, a woman, a 34-year-old woman, I believe he had met through some sort of social app, was horribly murdered, stabbed 30 times. He is on the hook for that murder. They found him and connected him to that murder because of an ATM card, a debit card, which he possessed and used. And once they nailed him for that, they got him to admit that he used the card, but he did not admit to the murder, which is going to be tried subsequent to this trial. So he's in jail, I think, on a 10-year run for that because it was the third strike, or it was some sort of multiple offense piling up that put him in there for a 10-year period for using a debit card. That's a little harsh for just using a debit card.
Well, he was a prior offender, so yes. I think oftentimes that results in much steeper sentences.
Yes, not a third strike situation, but similar.
Yes, similar.
So that's he was ready to go when they decided in this case that he was the prime suspect. He was easy to pick up.
Right. Do you think that the prosecution and the investigators on this case botched the case? I mean, it took a long time for them to indict Quentin Tellis, you have to admit.
You know, I think that's actually helpful to them, and I say that in this way, because they didn't rush to judgment.
Right.
You know,
damned if you do, damned if you don't.
It really
yeah,
is. It is. I think where they failed, though, is in itemizing or failing to itemize these Erics. You know,
Right.
we've had officials testify. Yeah, I spoke to every Eric. I don't have written down. You know, I don't have a list of them, but I talked to everybody. I think whether it's presented to the jury or not, because there could be issues, you know, implicating somebody who they did truly clear, it should have been evidence that was, or information shared with the defense, perhaps even in camera reviewed by the court to determine whether it was worth bringing in. But if I'm looking at it from the jury's perspective, I'm thinking, how do you interview 15 Erics and not even have a list of them, not even have any sort of record of those interviews? That, to me, makes it sound like you were targeting somebody else all along, and maybe you're just, you know, we're just going through the motions. We're not going to be accused of rushing to judgment here, because we've had 30 people on this case from every agency imaginable. We've blanketed the area. If your name was Eric, we talked to you.
Right. And I think there was even some discrepancy over exactly right, how many Eric or Derricks they interviewed, how they went about the process of collecting the Erics or Derricks that they would investigate. Quentin Tellis, of course, noted in his initial interview that there was a man named Eric who was stalking Jessica Chambers. I mean, I found that to be very, very interesting. And then we heard from the investigator saying he was completely cleared. He was home that night rubbing his mother's feet.
Of course.
And I thought,
well, who isn't?
Exactly, who isn't doing that? And I thought, now, I don't think a mother of an alleged murderer is the best airtight alibi
Not
out
the best
there.
corroboration.
No.
On the other hand, if you look at it from the prosecution standpoint, is this more of Tellis just creating alibis for himself by shifting the blame to a convenient Derrick?
Right.
You know?
But the question is, did Tellis at that point, was he aware of this dying declaration? Obviously, if he were, that would destroy his credibility. But if he were not aware, that would, to me, be a pretty strong indicator that maybe they should look into this guy more.
Legit. I'll tell you what I think, though. I think one thing he was aware of, if he's the person who did the crime, she was dead. He knows how it happened. Why not start shifting blame elsewhere, regardless of whether the cops heard about Eric or Derrick?
Right.
You know, maybe he's just throwing it out there.
Right.
You know, we don't know. We don't know exactly when he learned what he learned.
Right.
Remember, he learned about the death almost immediately when he went to the store and asked, hey, what's going on? Tight community. It wouldn't take much for him to learn that first responders heard the name Eric or Derrick.
Right. And I think we've seen that trying to be drawn out a little bit on direct examination from these investigators. We heard questions today about just how highly publicized this initial dying declaration was. I keep saying dying declaration, and there's a reason I keep saying it, because it, of course, is an exception to the rule against hearsay. Can you expound upon that a little bit for us, just as a primer for our viewers?
You know, you look at hearsay. Hearsay is unreliable because it's a statement made outside the court by someone other than the person testifying in court. That's the basic definition. And so what you look for then are, and it's riddled with exceptions. One of them is...
You could drive a truck through the exception.
Yeah, and in fact, it was one of, I love the class.
Yeah.
And it paid off so many times in trial that I really appreciate evidence and the hearsay rule. In this case, the idea is to look for the indicia of credibility. You know, what will make that kind of normally untrustworthy statement trustworthy? And in this case, the theory is, hey, if somebody thinks they're about to die, they're not going to lie to you. They're going to tell you the truth. You know, they want to, you know, whether it's spiritual, they want to unburden themselves, or in this case, somebody who's motivated to talk about who attacked her and ultimately killed her. It just tells the hearer that it's reliable, and that's how you get around the hearsay rule.
Exactly. I want to talk a little bit about another key piece of information that the prosecution is sort of hanging its hat on, which I don't necessarily think is as compelling as they would make it out to be, which is the fact that Tellis wasn't initially as forthcoming as he was in later interviews initially, right? So his initial story is that he was with Jessica the morning thereof. They dropped him off at his home, and he didn't see her again for the rest of the night. It was only upon sort of being faced with more evidence that, in fact, they were together that he then said, well, yes, actually, we were together that evening. We, in fact, had sex that evening. But the story he's telling is that they that Jessica contacted him to buy drugs from him. So as a defense attorney, in my mind, that says to me, look, maybe the reason this guy lied to investigators initially is that he just got out of prison on another sentence. He doesn't want to go back there anytime soon. He has another motivation to lie to investigators, which is he doesn't want to get caught on a drug charge.
Sure. And it could be as simple, too, as the relationship may not be well received by members of her family, others in the community. There are a few reasons for him to try and back off from what we now know was some continued contact.
Exactly. And he had a girlfriend at the time, right? So that's
girlfriend, wife.
Girlfriend,
I'm not
wife.
quite sure.
He had a lot of things going
very
on.
Confusing.
Right. So there may have been sort of more going on, more that meets the eye. I want to take you now. Let's look at a clip. I want to go to. We were just looking at the lead investigator on this case, and I want guys to go now to Barry Thompson again. I want to go to his cross-examination. That's QT58. We'll take a listen to see what he has to say, and then we'll come back and talk.
He came voluntarily?
Yes.
And he submitted to your questions?
Yes.
Did you get the impression that he was being dishonest during that interview?
You know, I mean, this was, you know, Mr. Peterson, we do interviews in two different ways. There are interviews and then there's interrogations. And this wasn't a pressing interview. This was a contact interview.
Certainly.
And it was just simply like a conversation like me and you were having. It wasn't a pressing interview like I knew that he was lying to me. I mean, it was just finding out where he was.
Yeah, I mean, but when you go out to interview someone who has come on your radar and you're trying to ascertain information, I mean, isn't it normal for you as a law enforcement officer to try to make some determination as to whether or not what they're telling you is credible?
Sure. I mean, we gather information and then we're going to follow it up by what he told us, seeing if I can, or somebody's going to run down what he told us.
Certainly.
Via his interview. But as far, this wasn't like I was an accusatory interview of him at the time. It was simply, did you know her? How did you know her? And where the last time you were with her?
And there were some aspects of that interview that apparently you took serious, because I believe you indicated that he told you the name of Derek.
Yes, sir. I mean,
I'm sorry, please.
In this interview, there would have been notes taken, and if I was asking him a question, most likely Tim would have been taking notes, and if Tim was talking to him, I'll take notes, because most of the time the interviewer is going to concentrate on just talking to the suspect. It's like I said, I wouldn't say he was a suspect at the time, because this was a contact interview. He was somebody that had recently been with her or contacted her, and we were just trying to ascertain what that contact was.
Well, I mean, in this case, Mr. Tellis was being questioned about a young lady who had died a horrific death just 3 days prior to.
Well, we questioned hundreds of folks the same way.
You questioned hundreds of
I mean,
those?
we questioned, I don't know how many people we questioned. I mean, there were many, many interviews done in this case. Everybody that we could find had ever been in contact with her.
Fair enough. Now, also during this interview, he indicated that, and please, Major Thompson, if I misstate some of your testimony, please correct me. It's not intentional. You indicated that he met Ms. Chambers through Keisha Meyer.
Yes.
Okay. And when you say he met her through Keisha Meyer, do you recall anything about that contact?
I think Keisha and Jessica were friends, and they hung out together a lot. Of course, naturally, the M&M store is right there close to everything in Cortland, and it's the only thing in Cortland. So, and if he knew Keisha prior to that, saw Jessica and Keisha together, that would have been my assumption of how he said, I met her through Keisha.
Okay, now Ms. Myers testified yesterday. She said that Jessica introduced her to Quentin. Would that comport with the information that you obtained during this first interview?
No.
So, during the first interview, it was your understanding that Keisha introduced Mr. Tellis to Jessica.
I guess you could say it that way. He said he met her through Keisha Meyer. So I guess introduction, I think in his interview he said he met her through Keisha Meyer, that Keisha gave him Jessica's cell phone number, and that's how they began communicating.
Now, you also indicated that, and I have a note here saying sex. Did he indicate during this initial interview that he had had sex with Jessica Chambers?
He told us that he had had sex with her one time.
Okay. He did not, did he isn't it true that he didn't indicate that he had had sex with her on December the 6th?
He never said he had sex. He said I had sex with her one time.
Did he actually specify a date?
I don't know, sir. It wasn't a specific date. He just said that they had sex one time previously.
Now, you also indicated that Mr. Teller says that at the time of the crime, he was with Mike and Shigard. I know those are Big Mike and
Yes,
Shigard.
that would be Michael Sanford and Terrence Shigard.
Okay. What was his understanding at the time of this interview as to the time of that crime?
He would have been given the timeline, I'm sure, whether it was myself or Investigator Douglas, of where were you at, probably between 5 and 8, or whatever the time that would have been late. As far as the actual how the question was asked 3 years ago, I'm not sure. It would have been a timeline type of interview.
Did you keep any notes from this conversation,
Yes.
Detective? And do you have those notes?
You should have them. I provided a copy, or there should be a copy in the file.
I do not have any notes from the first interview. Well, I've got his report. You've taken a look at your report,
Yeah.
and you indicated that at the time of the crime, he indicated that, and on your testimony, I'm trying to clarify that, you indicated that at the time of the crime that he was with Big Mike and Shigard.
Yes.
Did he indicate that he was with Big Mike on December the 6th, or did he give you a specific time that he indicated that he was with them?
As I said, Mr. Peterson, it would have been a timeline interview because he had told us that they had ridden around that morning, and then he had went back home, and that it was later in the afternoon when he had been with Big Mike and Terry in the sandbox.
Okay. Well, so do you recall the timeline you gave me?
Welcome back to the Law News Network. I'm your host for the afternoon, Caroline Polisi, and I'm joined in studio today with Michael Bryant. Thank you so much for being here, Michael.
Pleasure.
You're an attorney, and we love having you on here at Law News. We're currently on a break in the Quentin Tellis trial. He is on trial for murder of Jessica Chambers. And Michael, you and I were talking a little bit during this clip about the fact that this is a capital case. However, the prosecution has made it clear that they are not seeking the death penalty. They are, in fact, seeking life without parole. What do you take away from that?
I think the reason is, and we get some of the information based on the argument given by the prosecutor during the opening statement, and it's a little muddy as to when any intent might have been formed and whether the defendant thought Jessica was dead at the time he started the fire. I think because of that kind of muddiness, and hopefully the prosecution will enlighten us a little bit as we move through the case. But because of that uncertainty, I think it would be difficult for a jury to nail down the intent necessary for the crime that would qualify for the death penalty. I know they call it a capital case because the underlying charge carries that potential penalty, whether they impose it or not. So that's my take on it. Without knowing more from the prosecutor, that's my best understanding as to how they could possibly just say, let's not even bother.
It is a little confusing because, when we say a capital case, it is eligible for the death penalty. However, they don't need to show that he intended to kill Jessica Chambers. They only need to show that she died during the commission of the crime, the underlying crime, which is arson, of course, the setting fire to the car. And I want to talk a little bit more about the actual theory. We heard in the opening statement this sort of pontification from the prosecutors as to what they think the story is that happened. And correct me if I'm wrong, but is this a story you got that they had consensual sex, something happened to Jessica, she died. Somehow she died. Tellis panics, freaks out.
He thinks she died.
That's
the key.
Correct. He thinks that she died. He runs back to his home to get the gasoline can, somehow exchanges cards with his sister. There's a lot going on in that time period, but then goes back to the scene of the crime to light this car on fire, speeds away to go to get the green dot card. Then, lo and behold, Jessica is not dead. She somehow gets out of her car, stumbles on the highway, and first responders see her, and they take it from there. I mean, how believable of a story is that?
From the prosecution standpoint, at this point, it's unbelievable
Right.
because we've got nothing to support it except the prosecution's filling in those blanks,
Right.
and they're big blanks.
Right.
And he can do that at the end of his presentation of the case and his closing argument. Knock yourself out. But the jury needs the dots to connect.
Right.
And if there's a gap, as there is now, between them being together and her death, it's a big gap.
Yep.
And, we know some gasoline, well, we believe we'll see some gasoline was retrieved. We'll see that on some video. And we won't see it used, but we'll know it was retrieved, and it does link up with the expert's testimony today that there was gasoline used as an accelerant. Okay, that's helpful,
Right.
but there's still a big hole.
Big hole, big hole. And just for our viewers, not to get too graphic here, but initially I had felt that perhaps this was a rape gone bad, a rape that Quentin Tellis wanted to cover up. We now know that there is no evidence of a rape. There's evidence of consensual sex, but nothing in the autopsy report would indicate that a rape took place. So there goes that theory. Also, this suspicious that she somehow suspiciously died. I thought, okay, she's been known to do some drugs before. Maybe there were some hard drugs involved here. Maybe she overdosed. Nope. Yeah. Toxicology report came back. She had nicotine and marijuana in her system. No signs of an overdose.
Check that off. Yeah,
exactly.
So, the prosecutor suggested she was suffocated
right.
somehow, and I believe there's supposed to be some evidence of bruising to the body that was unrelated to the cause of death. I don't know that that's been presented. I have not.
Okay. I haven't heard that yet.
I haven't heard that, except through the prosecutor.
Right.
So that would lead you to believe, okay, maybe there was some sort of struggle.
Right.
He was jealous. Maybe she's seeing somebody else.
Right.
I mean, who knows what might lead to that kind of altercation. We just don't have the evidence of it yet. And maybe as importantly, we know motive is not an element of the crime, does not need to be proven, but me and my jury members want to know why. Why would this altercation break out and lead to his belief that she died? What happened?
Right.
It's tough for jurors to get beyond that sometimes.
And there's so much misinformation out there. This case was investigated very intensely right from the get-go, and there was a lot of theories floating around there that led investigators to, talk to different people around the neighborhood. They had different theories of this case, and there was misinformation being reported really in the news about the level of burn that had taken place in her esophagus, that in fact the accelerant was not gasoline, it was lighter fluid. I know that was going all over the newspapers. How difficult is it in a high-profile case, this jury, how are we sure that we don't have a tainted jury here?
Well, I mean, you can only do so much.
Right.
I mean, what are you going to do? You could have a Mississippi case, try it in L.A. I
Right.
mean, really, what can you do? Especially in this day and age where social media is so important, good and bad. I think all you can do is the best you can do with the logistics that are involved here. To cart these folks 200 miles from their home, lock them up in a hotel with limited cell access to their families. That is a tough job for these folks to do. I appreciate the judge is trying to move it along, get this thing going, work through the weekend, whatever it takes. Let's get this to the jury so they can do their job and go home. But the fact that so much is out there and has been out there, I think it's impossible to find a juror that has not heard something about the case. All you can do as one of the attorneys in selecting a panel is hope that you get people with open minds, that are honest, that are willing to look only at the evidence, that if they have learned something prior, put it aside, man. Just set it aside and try to understand what we're presenting to you here, because that's all that matters.
Right. We already have, remember, one juror was dismissed for using Facebook. So that person's out. I mean,
I don't know if that's stupidity,
right.
if it's arrogance. I really don't know how somebody could be so foolish to do that
right.
in light of, now you've been through the pool selection process. You've been qualified. You're in the jury. The judge is telling you at every opportunity, don't do these, and then you do it.
Right.
I don't get it.
Going back to qualifying this jury, one of the reasons that has been thrown out as to why the prosecution has come out stating that they are not going to seek the death penalty is that they didn't want to go through that extra hurdle, that extra burden of getting a death qualified jury. What do you think about that?
No doubt. I mean, no doubt. That is so difficult, and it takes so much longer. We've seen it in cases in Florida a lot, where the process to just get a jury is just onerous. So that was, again, if they thought they could prove it, I don't think they would have avoided that process. They would have done what they needed to do, but I don't think they felt comfortable in proving it.
Right, right. And yeah, a lot of people are saying, it's a circumstantial evidence case, perhaps that they don't feel comfortable seeking the death penalty when they don't have the type of direct evidence that one would hope to have in a case like that. But I agree, I think sometimes the procedural hurdles could be weighing into, it's an issue.
It's an issue. I think in this case you've got so many variables that have nothing to do with the evidence.
Right.
The race card, certainly when you're in the South, is always going to be an issue.
Yes.
So I think to ask a jury to find a man guilty and look at the specter of death is a harder sell than to find him guilty and put him away for life.
Ah, interesting, interesting. I want to take our viewers now to a clip from Justin Blount. He was the FBI director on this case, and he's going to talk a little bit about how Quentin Tellis came to be the primary suspect in this case. Take a look.
Take you back